Taking that deep breath before walking into your very first job interview is already terrifying enough on its own. But imagine adding the anxiety that you might be turned away or fired later simply because of who you are, your background, or who you date. For decades in the UK, the laws meant to prevent that kind of prejudice were a scattered, confusing patchwork of different rules. That changed with the Equality Act 2010. This single, comprehensive rulebook consolidated all those overlapping regulations into one strict legal shield. It explicitly outlines 9 protected characteristics, including age, disability, race, religion, sex, and sexual orientation, that cannot be used against you in the workplace. By standardizing these protections, the government forced every business in the country to audit how they hire, manage, and treat their staff. Let's look at how this plays out in practice. Say a tech startup wants to keep a youthful vibe, so they advertise a job specifically for recent school leavers only. Under the Act, that is direct discrimination. The business is legally required to completely rewrite its recruitment procedures, so anyone of any age has an equal shot. Or consider a trendy clothing retailer that refuses to install wheelchair ramps because it supposedly ruins the shop's aesthetic. The law states that failing to make these reasonable adjustments for staff and shoppers is an immediate prosecutable offense. Next, imagine a supermarket where management turns a blind eye to customers making derogatory comments about a transgender employee's uniform. That inaction constitutes illegal harassment. The Equality Act holds the employer fully liable unless they actively enforce strict zero-tolerance policies. These forms of direct discrimination and harassment are illegal acts that leave a business fully liable in the eyes of the law. Take a look at this organizational chart. If a senior worker at an accounting firm enters a civil partnership and suddenly finds their path to promotion blocked because of it, the firm is breaking the law. The same goes for an 18-year-old barista whose manager cuts her shifts after learning she's pregnant, rather than adapting her duties to avoid heavy lifting. Then there are less obvious barriers. Suppose a call center demands a local Scottish accent for a generic customer service role. That specific requirement creates an artificial barrier, heavily disadvantaging certain ethnic minority applicants without any valid job-related justification. The law classifies this as indirect discrimination, a blanket policy that inadvertently penalizes a specific protected group. Anytime management builds policies based on assumptions about personal lives or cultural backgrounds, they risk severe legal consequences. Let's round out the list. If a fast food chain refuses to shift a Muslim employee's break schedule by 15 minutes to allow for daily prayer, they are in breach. Companies are legally required to accommodate religious beliefs, as long as the request is reasonable and doesn't disrupt the core business. What about a sports store that pays its female shop assistants less than the male warehouse staff and makes everyone sign a contract promising never to discuss their wages? The Equality Act explicitly makes those pay secrecy clauses unenforceable. The goal is to allow direct gender pay comparisons to expose and close the gender pay gap. Finally, imagine a video game studio where a programmer is fired just for supporting a gay colleague who filed a complaint about homophobic office banter. Firing that supportive colleague is a specific offense called victimization, and it guarantees the studio a date in an employment tribunal. The legal shield extends outward. It covers the targeted individuals, but it also protects anyone who stands up for them or requests reasonable workplace adjustments. For businesses, the margin for error is gone. They can no longer cross their fingers and hope managers behave properly. They have to actively embed these rules into their daily operations. Look at the hiring process. Many companies now use anonymized applications, hiding names, dates of birth, and gender from hiring managers to remove subconscious bias from the equation entirely. Once hired, staff must go through mandatory training programs so that everyone from the mailroom to the boardroom understands their obligations under the legislation. Physically, compliance requires capital investment. Premises have to be upgraded with wider doors, ramps, or hearing aid loops to ensure total accessibility. And if an incident does occur, human resources departments are required to formally and thoroughly investigate every single allegation of discrimination or harassment. This chart shows a company's health, with financial reserves and public reputation holding steady. But if an organization fails to comply and is taken to court, the fallout is immediate. Tribunal fines and massive compensation payouts strip away capital, while public scandal guts their reputation. The Equality Act 2010 establishes a very simple baseline for the modern workplace. When you walk through that door, your ability to actually do the job is the only legal metric a business can use to judge you.